All right, well, we have some sidebar transcripts from Donna Adelson's trial. She must be throwing a tantrum right now because she put in a new motion for a new trial, and that was denied. She was trying to say that the judge was biased towards her, that he favored the state. And there was even one incident they talked about where the defense attorney was saying something and the judge reprimands them for talking over the judge. We actually do find out which defense attorney that is because it's going to be in the sidebar that the judge is going to include. Additionally, Donna Adelson was also going after the jurors who have come out and spoken out about this. One juror spoke on her TikTok account. The other juror came out and did some interviews, and she's going to try to use their words against them. Although I felt like it was really weak in Donna's motion where she was saying that, oh, well, one juror said that they were looking at me for my reactions, expressions. However, the juror quickly said in the interview that he wasn't using that to make his determination of coming to a guilty verdict for Donna Adelson, and that as a matter of fact, he tried to ignore her most of the time, not pay attention too much to her. And then for the TikTok video, well, it seemed like she was pretty clear that she was only posting after the trial was over to discuss her experiences about it. So that seemed really weak to me. Now, the additional stuff that Donna Adelson was talking about was the judge's ruling about the 2014 planner and 2023 planner. Remember, the judge ruled that we weren't going to have the entire planners to be admitted into evidence. However, only like the portion that the state had let in, right? I think maybe the entirety of the planner could have been let in if Donna Adelson testified to it, but she ended up not testifying. Maybe that's what the defense was banking on. And then when she decided not to testify, they were like, okay, well, let's figure out a different way to get this entire planner in. Because from their perspective, they were trying to show that, well, for 2014 planner, I don't know what they were showing because Dan Markel's license plate and car information was in the 2014 planner. That already looks pretty bad. For the 2023 planner, they're trying to show that, well, Donna Adelson was already planning on selling these items anyways as far back as January. And the fact that she was selling it right before her Vietnam trip doesn't necessarily mean she was selling it just at that time to fund her Vietnam trip. It's like, well, it could. It could mean that. I was actually working on a Koberger video and then this popped up and I was like, should I stream it? But it's going to be a short stream. So I was like, I'll just do a video. I don't know. Let me know if you guys prefer the streams or the videos, or it doesn't matter, either one. Sometimes I do the streams and then I also like chop it up to the videos as well. But I felt like this was going to be a pretty short one, maybe, even though it's 57 pages long. But don't be scared. It is actually not that long at all. A lot of it's just transcript and then like wasted space. All right. Order denying defendant's post-trial motions. Court for consideration of defendant's motion for leave to interview jurors, motion for a new trial, and renewed motion for the judgment of acquittal, all filed on September 15, 2025. Oh, that's right. I forgot to mention that the defense team also argued saying that, well, actually, the evidence doesn't support what Donna Adelson was found convicted of. So, for example, it was a first-degree murder, it was a conspiracy to commit first-degree murder, and then also the solicitation for first-degree murder. So, the judge just goes through that really quickly. So Donna filed this on September 15th. Now, I think they put in like a amended motion. I didn't read that one, though. Here is what the court finds. Motion for leave to interview the jurors. The defendant, Donna Adelson, seeks to interview two members of the jury in her case, jurors 5 and 7. Now, to interview the jurors, the motion must set forth allegations that are not merely speculative, conclusory, or concern matters that adhere to the verdict itself. Consequently, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceeding. So essentially, destroy, ruin the entire proceedings. Defendant's allegations do not establish at face value case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court. The argued reason for interviewing juror number 5, again, this is the one that interviewed with Surviving the Survivor, and they also interviewed with another TV station. I forgot the name of it. It escapes me. Is that he revealed how he considered the defendants reacted to the evidence and testimony during the trial. However, the defendant also notes that juror number 5 expressly stated he did not consider her reactions during deliberations. Defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. This challenge primarily concerns that juror number 5 observed the defendant's reaction during the trial. However, the court is going to go into, well, they're going to be in the same courtroom. So when you're on the jury, you're going to be able to see the defendant's reaction because of the proximity and, you know, the way the court is like set up, you're going to be able to see the person. So it's not like the jurors are not allowed to visually observe the defendant over the course of the trial. Accordingly, the defendant may not have leave to interview juror number 5. Here's for juror number 7, the one that went on TikTok. The defendant provided video recording of this post, and the court was able to locate the post on the juror's TikTok account. I wonder if the judge has a TikTok account, where it remains an active post as of filing this order. I think the defense tried to say that she deleted it or something, but it seems like the court says that it's still active. I don't know. It displays the following text over video of juror number 7. This is what juror number 7 wrote. When I told God I need a break and he makes it so I am selected to serve on a jury for a 2-week trial, won't he do it? I think that's a smiley face in there. It looks a little creepy. Along with a caption that reads, no work, no kids for most of the day. You know what heaven, yeah? I think that's why, yeah, you know, I think it means you know. That's her tag. Posted August 26, 2025. The juror was instructed not to communicate with anyone, including fellow jurors, about this case. No emailing, no texting, no tweeting, blogging, or any other form of communication. The court also concludes that juror number 7's TikTok post does not constitute communication about this case. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, alleged crimes, whether it was a civil or criminal case, or even the location of this trial. In other words, it was not about this case. As such, it is not juror misconduct. The TikTok post was not so fundamental and prejudicial as to vitiate the entire proceedings. So her post was not so harmful or bad to the point that it destroyed the proceedings entirely. There's actually a little transcript that the judge provided, and I really appreciated it. So it's a little excerpt from the jury selection, and this is what the judge told I don't know if they're potential jurors at this point. Yes, they haven't been selected yet, so they are potential jurors. So the judge says this, and I can't do his voice. I'm so sorry, Judge Everett. The case has received some publicity, and there also was a related case that took place almost 2 years ago. This process is going to be handled individually because you will not need to know what others may already know concerning this matter. However, before we start that questioning, I'm going to give you some very important instructions. Many of you have cell phones, computers, or other electronic devices with you. Even though you have not yet been selected as a juror in this case, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have actually been discharged from the jury selection or jury duty, you must not provide or receive any information about your jury service to anyone, including friends, coworkers, family members. If you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take, which is what she did. I think she mentioned that it was like 2 weeks long and that she was selected for the jury. However, you must not give anyone any information about the case itself or the people that are involved in this case. You must also warn people not to try to say anything about it to you or write to you about jury service or the case itself. This includes face-to-face interactions, phone or computer communications. In this age of electronic communication, I want to stress to you that you must not use electronic devices or computers to talk about this case. This would include tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Do not send or accept messages, including email, text messages about your jury service. You must not disclose your thoughts about your jury service to or ask any advice on how to decide on the case. Further, you must not read nor listen to any news accounts about this case until you have been excused in this matter. Please avoid the newspaper and television broadcast, particularly the local news station. Also avoid any social media or internet news sites concerning this matter as well. So I think the defense was being really nitpicky about her not avoiding social media and her not, avoiding TikTok. And they're like, well, we want to know what she could have been exposed to, right? However, she did make it clear in her TikTok video that she's like, well, for my For You page, which is like the algorithm that she gets like a lot of mommy content because that's the type of content that she consumes. So if that's the type of content that she consumes and she doesn't normally look at true crime stuff, it would make sense that she doesn't get true crime stuff popping up in her feed, even though it might be local to her area and it might be big to some of us and we follow it. She was like, yeah, I just get mommy stuff. Every person that was potentially a juror for this trial was given those instructions. This is what the court argues, that, well, the defense, they heard these instructions and they didn't object to the jurors being able to disclose that limited information, which is saying that you're selected for jury duty and how long the case would be. He's saying that juror number 7, her TikTok, well, it actually comports with this exception to the communication prohibition. Why does that sound weird when I say it out loud? Defendant cannot now use juror 7's compliance with this directive as grounds to interview her. Accordingly, the defendant may not have leave to interview juror number 7. The motion for leave to interview jurors is denied as to both 5 and 7. Let's move on to the next one. Motion for a new trial and renewed motion for judgment of acquittal. This is where the judge is going to address the defense's arguments that there wasn't enough evidence to convict Donna Adelson, not enough to support her conviction of first-degree murder, and then the 2 other charges. The court does not find the jury's verdict is contrary to the law or the weight of the evidence. The court concludes the greater amounts of credible... Sorry, I think my computer froze for a second. The court concludes the greater amount of credible evidence supports the convictions. The court relies upon its previous rulings. All direct and circumstantial evidence admitted. The evidence demonstrating defendant's consciousness of guilt and its own credibility determination of the witnesses. When I covered the defense's motion for a new trial, I talked about how I disagreed with what the defense was saying when it came to them arguing that Donna Adelson did not know about this whole blackmailing thing or extortion until September, months after Dan Markel was murdered. I went through some evidence that I thought was very compelling to support that, no, it seems like Donna was in cahoots with Charlie Adelson and that she was planning on having Dan Markel murdered. And there was like little tiny evidence here and there, but putting it all together, it looked really bad for Donna. I will say this though, I think it was a very crafty way to explain Donna writing those checks to Katie McBanois. Because if they were like, well, yes, she wrote those checks. Yes, the handwriting, the signature, that's all hers. Well, it's only because she was completely in the dark about everything. And then Charlie was the one that confessed to her months later that he was being extorted. And instead of doing something about it, instead of reporting to law enforcement, FBI, anyone, they decided to go along with it because they were just so scared of the gang members, although that story to me is like not very believable, but I think they did a pretty decent job at trying to spin that story. I just feel like they didn't, I don't know, was that really evident during trial though, that was the new story they were trying to come up with, that it was until September that Donna knew things? I felt like they brought up in closing, right? But throughout their cross-examinations and throughout their, I guess, direct testimony of their witnesses, was that very evident? Maybe it wasn't, I just forgot. The judge continues, stated succinctly, there is evidence in the record demonstrating overt actions, so actions by Donna Adelson that very clearly show that she was in furtherance for the murder for hire scheme. The members of a conspiracy may have more than one objective. The trial evidence demonstrates a defendant's objective for the crimes being completed as separate and distinct from her son, Charlie, the middle woman, Katie, and the triggerman, the 2 dudes. However, their combined acts resulted in the crimes committed and death of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts and the death of the victim did not terminate the conspiracy until the co-conspirators received their payments. The defense was also arguing that, well, there was no set amount that was given to the hitman and that they weren't paid until after it was done. They weren't paid ahead of time. And I was like, okay, they were still paid though. The trial evidence established defendant's connection to those payments. Thus, based on the unique fact of the murder for hire, defendant's case is distinguishable from Williams. I don't know where he mentioned Williams, or I don't know if the defense mentioned it in their motion. I tried looking for it. Well, I did like a really quick search and nothing popped up. Or I don't know if it's not reading the PDF properly. So in addition to the judge denying the interview of the jurors, the judge is also going to deny the renewed motion for judgment of acquittal, relying on his denial of defendant's initial motion for judgment of acquittal, all direct and circumstantial evidence admitted, and the evidence demonstrating defendant's consciousness of guilt. So her trying to travel to Vietnam to have a, what did Georgia kept saying to Donna's friends? Clearing mine in non-extradition country. Yeah, clearing mine, non-extradition country. Okay, you said it. Next one, decision of any matter of law which arose during the trial. Oh, this is the planners. The court does not find error in refusing to admit the complete 2014 and 2023 planners. The state introduced particular entries from the two planners, however, not the entirety of it. The defense was like, nope, we want to introduce the entire planner in this case in chief. Now, the court is saying that the request was untimely. Although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces a statement, Florida courts have generally allowed the adverse party to delay introduction the other part of the statement until cross-examination. Defendant's request was too late because it came after cross-examination of the relevant witnesses. I think this planner came in through, I forgot his name, but it was a guy that testified. I know what he looks like, but I don't remember his name. He testified about the planners and the contents of the planner. And I think that during cross-examination would have been when the defense could have said that, hey, isn't there more to these planners than what you're looking at with the jury, I guess? I guess that could have been the time for the defense to bring up that, like, oh, actually, it goes all the way back to January where Donna Adelson was actually planning on trying to sell these items. It wasn't until, when was it? It was in November, right? Where she escaped to, or tried to escape to go to Vietnam. I guess that's when the defense could have brought that up with the witness in cross-examination. And through that, that could have been expanded more into the entire of the planner being entered in and brought up in front of the jury, I guess. Even if the request was timely, the judge says, well, it doesn't matter anyways. It was improper because the purpose of the rule of completeness is to avoid the potential for creating misleading impressions by taking statements out of context. So calendar, day planners, they are divided into a series of pages corresponding with the days in a year. The court concludes that the entries the state admitted to evidence were not out of context. They were not one part of a whole. They were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. So admitting just the November portion, or was it maybe October that Donna Adelson was planning on selling those items? Well, even if she was planning on maybe selling those items previously, it seems like she was definitely planning on selling those items now because she wanted to fund the Vietnam trip or, get rid of as much items as she can while she has the time to do so. The defendant's invocation of the rule of completeness was properly denied, says the court. The court permitted defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing argument. The defendant argued the state did not want the jury to see them. In addition, the 2023 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner, such as inter alia, defendant's text messages, WhatsApp messages, the Google searches for non-extradition countries, the recorded conversations, the emergency fast-track visa, and a one-way ticket to Vietnam. What's interesting is that in the defense's motion, they also made two arguments out of their, when you make an argument out of both sides of your mouth. So it was like, well, Donna Adelson is not trying to avoid prosecution. Donna Adelson was not fleeing. And then they're like, well, she was fleeing because she was trying to avoid prosecution because she had just seen her son being convicted and she thought the state was going to come after her next. That was something that they didn't bring up in trial, by the way, that I don't remember. But they were trying to make that argument in their motion for the new trial, saying that, well, the state's going to come after Donna, and Donna was just trying to get away because of that. It's like, wait a second, I thought you were arguing the opposite. Anyways, the court is saying here that, well, even if they were to bring in the entire planner into evidence and, and introduce it to the jury, well, it doesn't support her argument anyway because there's other evidence that she would have to go up against. And again, her evidence against her was very compelling. It was her own messages, right? The WhatsApp, her trying to get out of USA and go to Vietnam, and her, being in a rush. And then there was that recorded conversation where she thought she hung up the phone with Charlie, but she didn't. And her trying to get it really quickly, the visa. So yeah, it doesn't look good for Donna. And I think them just showing the jury, hey, by the way, here's the rest of the calendar where she was trying to sell comic books back in January. I don't think it's really going to help her anyway. All right, other causes. The court does not find the arguments presented in this claim warrant a new trial, specifically addressing the defendant's decision not to testify. The court relies on the trial record. This is where we start getting some of the sidebar transcripts. I love reading transcripts from the sidebar because we don't get to hear what happened in the sidebars. There are not going to be transcripts of all the sidebars that happened during the trial, just the one that's pertinent to this court denying this motion. The court explained it had additional research and wanted to confirm the defendant did not want to testify. The court added, the reason why I am bringing this issue to the party's attention is only because I believe the appellate cases of the state make clear, prior to instructions and closing, the exercise of the fundamental right leans towards allowing the defendant to reopen her case if she wanted to testify. So it seems like even though the defendant rested their case, that would mean that if Donna Adelson changed her mind, she could have been like, hey, by the way, I want to testify. Let's reopen. Upon the court's inquiry, counsel responded, we've talked to her for somewhat lengthy period of time last night over the phone while we were preparing. She informed Ms. Fulford and my paralegal that she felt secure in her decision. Defendant was then placed under oath and asked if she was absolutely firm about the decision not to testify. Defendant twice responded, yes, I am, but asked for a few minutes to talk to counsel. The court then granted additional 30 minutes. Oh, see, this is what we didn't get to hear. It seems like she was prepared and she was like, yeah, she was absolutely firm decision. But then the judge was like, hey, we'll give you an extra 30 minutes. And that's when, okay, all right. And that's when I think the 30-minute was it during the lunch break? The court then granted additional 30 minutes to further discuss her decision. After that time had elapsed, defendant once again stated, I've made a decision. I am not going to testify. But I remember, I think it was it after the 30 minutes after the lunch where it seemed like she was wavering. So I don't know if she was solidified and then she decided to waver and the court seems to be impatient. After the time had elapsed, the defendant once again stated, I've made a decision. I'm not going to testify. When asked if she was firm in the decision, defendant answered, I am. The court concluded, I will make no further inquiry unless the state or defense seeks the court to do so at this point. Unless, neither party did. Accordingly, defendant was provided sufficient time to and did make a knowing, voluntary, and intelligent decision not to testify. In denying defendant's other allegations, the court relies on the complete trial record of the proceedings. So I guess in the allegations that the state was being heavily favored over the defense, that the judge was being biased, the judge is like, you know what? I'm not even going to address that. Y'all go read the transcripts, I guess. All right, let's go read the sidebar transcripts because, like I said, we did not get to listen to these. So it starts off with the jury. That's one that I read earlier. I'm excited to read these. Because there's different voices in here, I'll try my best to try to distinguish between the voices, but I don't really have a high range. But we'll try. The court. The parties can briefly approach. Sidebar conference as follows. The court. In researching some matters last night in anticipation of moving into closing today, I did want to confirm with the defense that the defendant is not asking to testify. Mr. Zellman. We talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Miss Fulford and my paralegal they had taken her off speakerphone at that point, that she felt secure in her decision. If Your Honor would like to have Mrs. Adelson come to the bench, I can have her. The court. Just have the bailiff bring her over here to sidebar. Mr. Zellman. Yes, sir. The defendant present. Donna Adelson. The court. Mrs. Adelson, before we move into instruction on the law and the closing arguments this morning, I, once again, want to confirm with you that you are firm in your decision that you're choosing not to testify. Donna. Yes, Your Honor, I am. The court. You are absolutely firm about this decision? The defendant. Yes, I am. I don't know how to do Donna's voice, okay? It'd be different if it was like Elaine or something, or if Donna was like a heavy smoker. The court. Is there anything further that you need to speak with your two attorneys about on this matter? The defendant. I would like a few minutes to talk to them, yes, if I could. The court. As to this particular decision or some other matter. The defendant. As to this particular decision. The court. On this, I will provide a few moments. After this, we do need to resume timely. Yesterday, when the court made reference to contempt, this concern has continued to occur. Wait, contempt? Where are we in the timeline? Was there discussion of contempt in sidebar before? Because I know he threatened contempt when he really told them to make a decision, and they were like wavering, and then they were like kind of like, talking on the side, and the judge was like, I'm not talking for the sake of talking. I think this is before. Oh, okay. So this was on September 4th. This was the day after the judge threatened them with contempt, where Donna and her team were still conferring on the side, and then the judge was like, hey, I need a decision like right now. Yesterday, when the court made reference to contempt, this concern has continued to occur, and also not returning from the conferrals. We need to resume court. If you need to speak to your attorneys now concerning whether you wish to testify, I will allow you to do so. I'm going to give you 10 minutes to accomplish this. When 10 minutes is up, we do need to move on. Ms. Kappelman. Judge, is this your intent to go right into instructions and closing at the conclusion of the 10 minutes? The court. That will be my intent. Ms. Kappelman. I would request 30 minutes because I need some time to get my closing act together, so maybe that can give a little more time for the defense to do what they need to do as well. Both parties need to share their closing PowerPoints and demonstratives with each other too. The court. We'll make it 30 minutes then. Now, the defense in their motion, when they're complaining about the judge favoring the state, Ms. Kappelman and Sarah Dugan, they were saying that, well, the court was rushing Donna on making decision to decide whether or not she was going to testify. However, the court was giving all the time to the state to set up their PowerPoints, to set up, their demonstrative and stuff like that. It just seems really unfair. The court. We'll make it 30 minutes then. The reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear, prior to instructions and closing, a request to reopen the case or the defendant to testify, the exercise of the fundamental right leans towards allowing this to occur. I'm giving her this last opportunity to confer with counsel and make this decision. Ms. Fulford. May I say something, Your Honor? After the state is done with their closing, we're going to need a break for some time to set up our stuff. The court. That's fine. Will any recordings be used as a part of closings today? Ms. Fulford. Yes. Ms. Dugan. May I ask one more thing? Is it the court's intention to read the stipulation prior to jury instructions? The court. Yes, because that will be part of the evidence in this case. Well, it seems like the defense, they also had stuff to set up, and the judge was fine with that. They made it seem like they had stuff to set up, and the judge was like, no, not you. I'm going to allow the state to set up their shit, and, you're screwed or something. All right, sidebar conference concluded. I think this was in open court, so we got to listen to this. The court. Before we bring the jurors in, we will have a brief break to allow the parties to set up any demonstratives and presentations that they will need for closing arguments. Please inform the jurors that we will bring them out about 9:25. Until then, the parties may do what they need to do to set up to get ready. I will print the copies of the instructions. If anyone needs to stretch their legs, use the bathroom, please do so. As to all observers for the closing arguments today, and this is very important, once again, you are not to make any gestures, not to make any facial movements. You are not to in any way indicate to the jurors that you agree or disagree with what is being argued or what is being said. Phones need to be put away and placed on silent or turned off. Does anyone have any questions? Given what was brought up yesterday, that there was either murmuring or some proper... Oh, that's right. So the defense also complained about how there were people in the audience that were, making some sounds that made it seem like the defense, was being laughed at, and the judge didn't do anything about it. However, I think it's hard for the defense to pick out who was doing what, maybe, unless they went back into the live stream and were able to pick it out through there, depending on where the camera was pointing towards. I think the judge maybe was unable to catch who was doing it, because if they did, they would just have the bailiff, kick out that person. So I think maybe the judge tried his best. When Mr. Zellman brought up the issues, the judge addressed it to the open audience to let them know, hey, you guys can't be making any reactions or anything like that because you might be influencing the jury. Judge says, does anyone have any questions? All right. You will be removed and also subject to contempt. Please raise your hands now if you have any questions. Otherwise, I expect you to conduct yourselves accordingly. We will resume at 9:25. The parties are to prepare for closing at this point for all the preparations and demonstrations. The court goes into recess. The court. We will need to wait for the state to arrive, but there is one matter involving the introduction to homicide in that instruction that needs to be addressed. It refers to the lesser, so that will be edited before we get started. Mr. Zellman. Yes, sir. The court. Mr. Evans, Mr. Zellman, if you can approach. Sidebar conference is as follows. The court. I just noticed this when I was running the copies, but if the lessers are going away as to the introduction to homicide, I cannot see a basis for which they need to be referred to. As to any references of the justifiable or excusable homicide, is there any basis to even discuss this if the jury is not going to be instructed on them as well? Mr. Zellman, I think we conceded that yesterday, Your Honor. Mr. Evans, we all agreed to the removal. The court, all right, let's do this. Then, as to the first sentence, the first sentence describes the accusation. The second sentence goes into what the lessors are. I cannot see a reason to give a sentence at all if there are no lessors. All right, so I guess based on where we're moving right now, it seems like we are moving in order, and that when the judge talked to Donna again to make sure she was really set in stone that she was not going to testify, that was done after the whole showdown between the judge, the defense team, and Donna Adelson, and then when she finally said that she was not going to testify. So I was just trying to figure out where we were in the timeline, whether it was before that happened or was afterwards. It seems like this was afterwards. So after Donna Adelson said she wasn't going to testify, the next day, the judge was like, hey, I really looked into this and you can reopen your case and you can choose to testify if you want to. And Donna was like, no, I'm not going to testify. Were you able to speak with your client concerning in her decision firm? That's why we're here. Mr. Zellman, that's what she said to us. Yes, Your Honor. The court, all right, let's have her place then on the record and we'll bring in the jurors after I finish printing these pages. Mr. Zellman, do you want me to have her? The court, yes. Ms. Kappelman, Ms. Dugan, Ms. Fulford, if you can join us at sidebar. The defendant, present. The court, just so all the parties are clear on what was discussed concerning the jury instructions, with there being no lesser included offenses that will be considered by the jury, the second and third paragraphs of the introductions will be removed, and the second sentence in the third paragraph will be removed. So remember, they took out the lesser included because I think the defense was like, hey, Donna, if you get charged on a lesser included, you're kind of done for anyways because you're already almost in your 70s. I think she's either early 70s or late 60s. I forgot. However, let's take away the lesser included, and then let's just leave on the most serious of charges on there. Because I think the defense, they thought they had a chance of the jury wavering or not being willing to convict a grandma with first-degree murder because they didn't think there was enough evidence that proved that. Because again, maybe there was a lot of evidence that the defense thinks that for sure Charlie was responsible when they were trying to put it all on Charlie, put it all on Wendy. But they were like, oh, not poor Mrs. Grandma Adelson. She wasn't involved in this. She was just a poor old lady who was just trying to, help her son out by giving money to Katie. All right, continuing with the judge. Concerning other matter that previously came up during sidebar, Mrs. Adelson, you remain under oath. As to whether you wish to exercise your right to testify in this trial, have you made a decision concerning this? The defendant, I have made a decision. The court, what is that decision? The defendant, I'm not going to testify. The court, you are firm on this decision? You are firm on your decision? The defendant, I am. So again, this is all happening in sidebar. We didn't get to hear this. The court, very well. I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. Ms. Kappelman. No, Your Honor. Mr. Zellman. No, Your Honor. The court. The quality on I think my mouth is really dry. The colloquy on this subject matter is united through the multiple discussions that occurred the previous day of trial and on this day as well. I will print an updated version of page 1 of the instructions. Everyone will receive a copy from there, and copies were provided to the jurors so they can follow along. Are there any requests or questions? So it seems like the judge, decided to do a little bit more research on Donna Adelson not testifying, and then him kind of like pushing her to make the decision. He just wants to make sure, like, hey, I understand that even though you rested your case, defense, you can reopen your case, and if Donna Adelson changes her mind and she wants to testify, then she can do so. Mr. Zellman, and Your Honor, my understanding is the state has a lengthy PowerPoint. We'd like an opportunity to review that before they do their closing. The court, all right, I'm going to go through and make these changes and getting their copies run. How long do you believe this will take? Mr. Zellman, how long is it? Ms. Kappelman, it was a pretty long presentation. I think Kappelman took about an hour and 40 minutes in her closing, and then 20 minutes maybe for rebuttal. Excerpt from sidebar conference as follows. Where is this from? This is 2 days before, September 2nd. Mr. Zellman. And so our family law expert, we always intended to have her testify. Subsequent to that, we're still trying to make arrangements now that we've gotten clarifications of the court's position concerning Miss Delgado. Oh, is that the attorney? We're still trying to make arrangements to get her over here. So we have, I think, 6 or 7 witnesses set for today. I don't know how late that will take us. We just were not able to get the other ones here. The court. So between today and tomorrow, you expect the defense's case to be presented? Mr. Zellman. Yes. We would ask for the court's indulgence tomorrow afternoon so we can have some additional time to speak with our client concerning her decision to testify prior to her actually testifying. Obviously, it's her right to decide, and we just want to make sure she understands everything. The court. I'm not going to press her on the matter, but this is an issue which essentially has been from the time of indictment. Will you testify at trial? Mr. Zellman. Yes, I'm not saying that we have not discussed it with her. The judge. Correct. Mr. Zellman. Since almost day one, it's the court. You will have an opportunity to discuss or to speak. You will have an opportunity to speak before any colloquy is done concerning whether you will or won't testify. Mr. Zellman. My understanding with the length of the witnesses that we anticipate for tomorrow, we will not be calling her tomorrow if she chooses. It will be Thursday. The court. All right, concerning that, depending on the defendant's decision, well, it depends. How many witnesses will you have to call on Wednesday? Mr. Zellman. If everything lines up the way that it's supposed to, between 5 and 6, the court. Okay, I will certainly give you a reasonable amount of time, but if, say, we get to lunchtime or a little bit after lunch on Wednesday, if you need a half hour or so to speak to her, I will certainly give that to you. But to recess for the evening, there's been an opportunity to go over this topic for nearly 2 years. You met with her on Saturday as well concerning trial strategy? Mr. Zellman. Saturday and Sunday. Yes, Your Honor. The court. All right. I will give some additional time in the courtroom, but depending on where we are falling clockwise, the jurors will want to get back to their lives. Mr. Zellman. Yes. The court. We do need to move on this in a timely fashion. Mr. Zellman. Yes. And there's one thing I wanted to address at sidebar. Go ahead. Oh, that's all we get. What are you addressing? Here's another sidebar conference. The court. All right. For today, that's the last of your witnesses. Mr. Zellman. Unfortunately. The court. All right. The person that you need to speak to at the jail, this gives you your opportunity to do so this afternoon. Also, you can speak with your client concerning testifying. Tomorrow, how many witnesses are you anticipating? Mr. Zellman. Marisol Descalzo flights gets in about 10, I believe. At least that's what my paralegal, Ms. Castor, told us. They're the witnesses that we have for tomorrow. Dr. Ruth Rosenberg, Kirsten Adamson, Linda Bailey. Wait, Linda Bailey, was that the attorney that testified and completely got destroyed by Georgia? Was it? I think so, right? And there's potentially one more in addition to the new one. I'm just drawing a blank. So 5, 6, the court. All right. That should put us time-wise more or less around same place. Is your client going to be ready to testify tomorrow? Miss Fulford. It depends on what happens when we speak to this next witness. I suspect that it'll be Thursday morning before she'll get ready to testify. The court. Well, not when she would prefer to testify. Miss Fulford. I misspoke. The court. But if we only have this many witnesses, Miss Fulford. I misspoke. The court. Go ahead. Miss Fulford. Because of the evidence that came in the trial and some rulings that the court made, it may affect her decision on whether she wants to testify. Mr. Zellman. Specifically, there were some additional things that the state added during their case, and although we had access to the materials, we need to go through the exhibits to see exactly what was admitted in terms of emails and other documents so that we can go over that with Mrs. Adelson. So we're going to need a little bit of time with the clerk to go through that today when the jury leaves. The court. All right. State, do you need to be heard? Ms. Kappelman. I would like an opportunity to depose a witness over the lunch hour tomorrow. If you're going to have a new witness, that person is going to be permitted to testify. I know I'm getting a little ahead of myself, but for planning purposes, I can do it tonight. I can do it before court tomorrow, or I can do it at the lunch hour. But I do want to be given at least the opportunity to do that if the person is going to be permitted to testify. Mr. Zellman. As soon as we speak with her and we make a decision, I will certainly get in touch with Ms. Kappelman, Ms. Dugan, let them know if they're going to use that individual and who they are. All right, that's Mr. Zellman. All right, I will send the jurors home for the day. Are we on the same day? Oh, no. What day are we on? September 3rd. So a day before September 4th. The first sidebar that I read was September 4th, and then we would jump to September 2nd, and now we're moving forward back to September 3rd. So you guys are aware of the timeline. This is from the jury trial. I guess I'll read it. The court. For today's witnesses, let's go through that before the jurors are brought into the room. Mr. Zellman. And I apologize. I did not have a chance to prepare the list. At least for the morning, our attendants to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Maricel Descalzo. The court. For this afternoon, Mr. Zellman. This afternoon is up in the air, and that's going to require some additional conversations with our client. The court. During the lunch break, that will be your opportunity to have any final conversations concerning whether she will in fact testify. We will give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30. After that, we're going to go on the record concerning is she or is she not testifying? Mr. Zellman. Yes, sir. All right, I think we're back after the lunch break, I think. The court. As to the other matter concerning whether Mrs. Adelson will testify as part of the defense case in chief, Mr. Zellman, were you able to speak with her to a final decision? Mr. Zellman. I will allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Mrs. Adelson. Oh, this is what we got to listen to. The court, in addition to the time that you had yesterday and other times, Mr. Zellman, yes, Your Honor, Ms. Fulford, if I may judge, the issue is that the court, well, one moment, who's handling this matter? We're not tag teaming any arguments of any sort. Mr. Zellman, Your Honor, what Ms. Fulford and I have discussed with the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court. The court, Ms. Fulford, go ahead. Ms. Fulford. The issue we're facing, Judge, is that this was 6 days of testimony from witnesses from the state and a great deal of witnesses that we have entered. We have discussed with our client, of course, her right to remain silent as to whether she wants to testify or not. We have not had an opportunity to go through all the evidence that was entered in this case and have a full and frank discussion with her about that evidence. If there's any issues that she thinks needs to be addressed for her testimony, whether she thinks she needs to testify or not, what her decision is on that. The court. When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she was to testify or review the evidence? Ms. Fulford. Absolutely. Yes, Judge. And that's what I said. We have discussed with her whether she wants to testify or not. The court. The defendant in every single case, Ms. Fulford, is faced with a moment as the defense case in chief ends. What are you asking for? Ms. Fulford. I'm asking for additional time to be able to go through all the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case. The court, Ms. Fulford, concerning that is provided by the court. If she wishes to testify, we do not go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during the trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify. Ms. Fulford. Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent some time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial, but some things being added, some things being removed. So we wanted to make sure we completely understood, or we understood completely what was there. We left here, went straight to the jail. We had the issue with a potential new witness and spoke with our client, but that's not ample time to discuss with her what was actually coming to the state's case. The court. Your client is no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 minutes to discuss this matter. From there, the defendant's going to have to make a decision whether she's going to testify or exercise her right to remain silent. And I think this is where, they were talking on the side, right? I think this is where they were talking on the side in like a little full circle, I think. Your Honor, may we approach our client with your client? Ms. Fulford, yes, please. Why not address this matter when the jury's out of the room? Mr. Zellman. Judge, the concern that we have raised a number of times, a response from the audience concerning things that were said by the defense. This is when he was upset because he says the peanut gallery, they were making comments, they were laughing. We are respectfully requesting the court here, allow Mrs. Adelson to participate at sidebar as she is entitled. All right, please approach. We're not going to do this very long. All right, here's the sidebar. This is what we didn't get to listen to. The court. Mrs. Adelson, you remain under oath. Go ahead. The defendant. So my concern is that I was hoping to have some time with my attorneys to go over evidence that I can make an intelligent and informed decision, and 5 minutes is not going to do it. The court. Mrs. Adelson, this has not been simply about 5 minutes. From the time that you were indicted, through going through discovery, through the pre-trial process, through the start of the state's trial, you have had the opportunity to confer with counsel and decide whether you wish to testify. As far as what has come out during trial, certainly you have been able to listen to this and make your decision, but it's time to make a decision. Defendant. But I thought I would be able to consult with my attorneys in making a decision, not just, I'm a layman. I'm not just making it on my own. The court. Are there any other legal arguments that you have to make concerning this? Mr. Zellman. Your Honor, the concern that I think my client is inartfully phrasing is that in order for her to make a decision, she's still on the fence. We have to been able to explain to our client the evidence that has come up to a certain point. We have not been able to go over everything with her. The court. Mr. Zellman. To that point, this trial is no different than any other criminal trial that occurs in the state where the attorneys and the defendants observe the evidence of the state and then have to make a decision. You have been able to consult with your client. I believe you said you went and saw her on Saturday. You had yesterday. The issue of testifying has not come up. Is that what you're trying to say? Mr. Zellman. No, Your Honor, that's not what I'm trying to say. What I'm saying is that when we started up representing Mrs. Adelson, there were a plethora of issues that she felt should explain to the jury. She has now told us for the first time during lunch break that there was only a couple of questions in her mind, meaning whether or not she exercises her constitutional right to testify or to not testify. We're not asking for a lengthy period of time. We originally said that a defense case was going to take 4 to 6 days. We're now halfway through second day. And all we're asking for is that to get the additional witnesses that are today, give us the opportunity, give her the additional time so that she can make a decision, so that we're not put in a position where we're looking at a potential ineffective assistance of counsel issues because she gets cut off at the judge. Although you have prepared her, Mr. Zellman, we have, but the decision has obviously seriously I'm messing this up. But the decision, it has obviously serious consequence. Whether she exercises her right, exposes herself to cross-examination, or whether she is satisfied with the advice that we are giving her concerning her right to testify. The court, whether it is this afternoon or tomorrow morning, the situation remains the same. She must choose concerning whether she will testify or not. Mr. Zellman, I understand that, Your Honor. The court, does the state wish to be heard? Ms. Keppelman, my concern, Judge, is we've told this jury that the case is going to conclude Friday, right? The court, 3 weeks. Ms. Fulford, you said the 8th. The court, possibly the 8th. Ms. Fulford, don't interject. This is the state's opportunity. Ms. Fulford, I apologize. Ms. Keppelman, yeah, I don't really want to give it to them on Friday night. I don't see what the purpose of another delay is. We've had lots of delays. I do appreciate that it's a very difficult decision, but it has to be made. I don't think it's going to get any easier tomorrow morning than it is this afternoon. So I would ask to proceed and use all the time that we have reserved with the jury as wisely as we can. The court, how long do you think the examination of the witnesses are going to take this afternoon? Mr. Zellman, 2 witnesses this afternoon, Ms. Newhouse, I think direct and cross, 15, 20 are plenty to authenticate and exhibit through her, and have it introduced, but not publish it. And then Ms. Descalzo, cross, direct, I don't see it going more than 30 minutes, Your Honor. The court, this is starting to sound like an issue as it relates to the lack of preparation. You have discussed with your client what her testimony will be? Mr. Zellman, if she testifies, yes, Your Honor. The court, you have prepared her for this direct and cross-examination? Mr. Zellman, as best as we can. The court, how many times, if you can estimate, have you discussed whether she would testify in this trial? Mr. Zellman, I'm going to have to refer to Ms. Fulford about that. So the feeling that I was getting throughout the trial from the defense's side, it seems like they were at some point or at some parts not very well prepared. And I do get it that when you're comparing yourself to the state, the state probably looks stellar because they've had multiple trials to go through with this, going after and prosecuting other defendants. But I'm just comparing the defense to, I guess, like other trials as a whole and other defense attorneys. It just seemed like it was just not as clean and a lot of I don't know. I don't know if just the teamwork was just maybe lacking. Maybe there's not like chemistry between Zellman and Jackie when it comes to, being co-partners on this, murder trial. Ms. Fulford, whether she would testify, whether she would testify, just that simple subject has come up lots of times. But actually preparing her and going through the evidence that's been admitted, we're trying to. The court, this is not about Ms. Fulford. Do that now. The court, going through each piece of evidence. Ms. Fulford, I'm not talking. The court, this is whether she's prepared to testify. Ms. Fulford, well, she's had indicated that she's not because she hasn't had an opportunity to discuss the evidence with us, what has come in and out, and what needs to be addressed. The court, Ms. Fulford, how is this case different from any other Florida case where the defendant must make a decision at the conclusion of the state's evidence? One-day trial happens routinely. Ms. Fulford, right, I understand that, Judge, but this is not a one-day trial. The court, no, it has. Ms. Fulford, the state used, the court, hold on, don't speak over me. There has been multiple opportunities for you to discuss with your client the substance of her testimony, what she would testify to, and we're at the point where it's time to make a decision. This does not sound like good cause for a further delay. The defendant, may I say something, Your Honor? The court, speak to your attorneys. Mr. Zellman. The question that Mrs. Adelson had, the statement that she's asking for the remainder of the afternoon after all the other witnesses testify, and so that, and she will make a decision at that point. The court, once the witnesses finishes with their testimony, at that time, we will revisit this issue. Concerning whether the direct will start this afternoon is a separate matter from whether she is planning to testify. I need a decision concerning whether she plans to testify at the conclusion of the other defense witnesses. Mr. Zellman. Yes, sir. The court, please return to your table. Sidebar has concluded. Oh, man. All right. I think this is an open court now. I think. The court. This brings us back to where we were concerning whether the defendant is going to testify in this matter. If there are no other witnesses for the defense, it is time for the decision to be made. Mr. Zellman. I can tell the court that the co-counsel and my client are in deep conversation concerning this. Oh, I remember this because he was narrating. The court. I'm capable of seeing that, Mr. Zellman. No narration is needed. Ms. Kappelman, once the defense rests, is the state intending to place or put on any rebuttal case? Ms. Kappelman. I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify. The court. Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon, and this is when he asked her, are you going to testify? And she's like, yes. She's like, no, I'm not going to testify. Do you understand that? And she's like, yes. All right. So she was like, I'm not going to testify. Is this where they, hold on. Oh, no. This is where she's like, she's not sure. She's wavering. Well, it doesn't seem like she's wavering. She's like really not sure. And Mr. Zellman jumps and was like, hey, Jackie's been talking to her. Let me talk to her. And he's like, what can you achieve that's different from Jackie? And he's like, well, let me try, Judge. Let me try. So that's what happens. This is where I think the threat of contempt happens. All right. So Zellman talks to Donna for about 5 minutes, and then they all come back. The court. Mr. Zellman, Ms. Fulford, Mrs. Adelson, the extra time you have had provided, that has come to a conclusion. We're not finished with a colloquy quite yet. I can't say I can't say that word when I'm trying to do like this like deep voice, I think that's why it's hard. We're not finished with this colloquy quite yet. Pause. The court. I'm not talking for the sake of talking. Mr. Zellman. Sorry, Your Honor. The court. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights? At this time, I don't want to testify. Very well. I have previously stated the jurors will be instructed that your silence cannot be held against you in any way. End of excerpts. Okay, you know what? I guess I could have live streamed this. I didn't. Yeah, it is kind of long. Whoops, my bad, guys. All right, what is this exhibit 1? This is the TikTok of juror number 7. When I told God I needed a break, he makes it so I'm selected to serve on a jury for a 2-week trial. No work, no kids for most of the day. You know what? Heaven, yeah. All right. I think that's it. Whew. All right, y'all. Well, that is it for today. The motion has been denied by the judge. I thought the state had a chance to reply before the judge makes a decision, but maybe not. Because I was really looking forward to reading what Georgia would have to write. All right, y'all. I got to hop on and work on the coworker video. Guys, thank you so much for watching. That's about it. If you guys have not seen coverage on the Donna Adelson trial, or if you're like, hey, the trial is 7 days long, I don't have time to watch 8-hour trials, go watch my recap videos. We did recap videos for each of the days. They're about, I think they range from like 30 minutes to like an hour, maybe 2 hours max tops. But feel free to check them out if you guys want to. If you guys haven't seen the defenses, when they put in a motion for a new trial, go check out that video as well, because I do go through it and then I put in my opinions as to why I disagree with what they were saying. So feel free to go check that out. All right, y'all. Thank you so much for watching. I'm sorry I haven't been doing the live streams. I was going to do a live stream in this one, but I was like, no, just maybe I'll just do a video. And then, yeah, I don't know. I guess it was a lot longer than I thought. I could have live streamed this. All right, y'all. Feel free to join the Discord. We do have a true crime section in there. If you have any other cases you're interested in, feel free to put it in there. We also have non-true crime sections as well. If you want to post pictures of your cute pets or cooking stuff, I don't know, share pictures, feel free to join that. Other than that, y'all, thank you so much for watching. We do have a second channel. Feel free to check it out. It's Hey Corgi-san. Working on a vlog for that soon. Ooh, oh gosh, guys. Thanks for watching. Bye.